Welcome to the next. It's the third session of our event today. It will focus on artificial intelligence, e-books, and libraries. Before we start, just a short announcement that the certificates of attendance are ready at the registration desk. For those of you who want to have a certificate, please visit the registration desk outside this room at the end of the conference. So for the third session, as I mentioned before, we have 5 distinguished speakers. We start right away with Dr. Marinos Papadopoulos. A short note about his CV. He's an attorney at law registered at the Athens Bar Association since 1996. And he's an active participant in international fora related to internet law, information society, and digital strategy. And he was the legal advisory to the National Library of Greece. And currently, he's a legal advisor to the World Bank Group on subject matters per the new judicial map in the justice system of Greece. Dr. Papadopoulos will talk with a special title. My name is Nobody, Oūtis ἐμοί ὂνομα. It's from the Homer Odyssey. And so, Dr. Papadopoulos, the floor is yours.
Thank you very much. Good morning, ladies and gentlemen. The subject of this speech is on artificial intelligence and copyright law. Artificial intelligence works have been widely reported in the press in the recent years. There are some notable examples of works created by AI. These are works attributed to computer-generated creativity solely. Does it work? Okay. Possibly the most recent notable example of art piece generated by AI creativity is the painting titled AI God Portrait of Alan Turing, which was created by... which was created by IDA, an artificial intelligence robot introduced in 2019 by British fine expert Aidan Miller. The AI God Portrait of Alan Turing was created by the robot IDA as a tribute to Alan Turing, the pioneering mathematician whose work laid the foundation for modern computing and artificial intelligence. Though it was estimated to be sold at the price of 120,000 USD to 180,000 USD, it was finally sold last month at the price of 1.08 million USD after a barrage of 27 bids in a Sotheby's auction. Sotheby's commented after the auction that this event marks a milestone in the history of modern contemporary art, reflecting the increasingly complex intersection of artificial intelligence technology and the global art market. In the realm of books of literature, Ray Kurzweil's cybernetic poet is a patented method of generating an artificial poet capable of reading poetry works, analyzing their structure, and coming up with its own outputs. The RKCP reads an extensive selection of poems from an author and uses a type of neural network algorithm to produce recursive poetry that can achieve the language style, rhythm, patterns, and poem structure of the original authors. The artificial neural network is an AI approach based on biological networks that use neuron equivalents based on mathematical models. There are thousands of examples of AI-created works in all creative and arts and literature. The question that might pop up in your minds while hearing these examples are, who is the creator of works created by AI, computer-generated works? And do AI works or computer-generated works have a creator in the legal sense of right holder of copyright? The answer to these questions is given in the title of the speech and presentation through the phrase taken by Homer's Odyssey, Oūtis ἐμοί ὂνομα, which translated in English means, my name is nobody. There is nobody as the creator of works created by AI, and there is not, in the legal sense of right, holder of copyright on AI-created works, at least for the time being, in most legal systems for copyright around the globe. AI-created works and computer-generated works are works in the public domain. The Berne Convention requires member countries to grant authors, meaning human authors, economic and moral rights. According to the Berne Convention, the person who created the work is the copyright holder. That is to say, the human author of the work holds the economic and the moral rights of copyright upon his work. There are exceptions to this principle, including in the Berne Convention, which contains a set of rules determining the initial ownership of rights in cinematographic works, for example, Article 14bis of the Berne Convention. However, in the Berne Convention and ever since in copyright law, the principle of truth lies in the foundations of intellectual property. According to the principle of truth, subject, original beneficiary, and original possessor of the copyright is the creator, the human being who actually created the work. This principle is also referred to as the principle, the creator's principle. This principle lies in the anthropocentric foundations of intellectual property law set by the end of the 18th century. From this principle of truth comes the moral right in copyright law, while a number of other principles are also based on the principle of truth, such as the interpretation of the originality criterion in light of the author's personal contribution for the creation of his work, as well as the principle that there is no need for any formalities for the acquisition of copyright. Because of the personal nature of copyright protection, there is no such thing as non-human intellectual property. Or intellectual property rights. Despite some recent legal disputes regarding monkey encephalographs, the monkey selfie case in Naruto versus Slater et al. Case, it is highly unlikely that we will witness a deviation from the principle of truth in copyright law and from personhood as a requirement for ownership. It is unlikely that we will witness, at least in the continental legal system applicable in Europe, any sort of allocation of rights towards machines or animals. In the EU copyright law, the subject of intellectual property is mentioned in Directive 250 of 1991 on the legal protection of computer programs, in Directive 29 of 2011, in Directives 83 of 1993 and 98 of 1993 for the duration of copyright protection and certain legal rights. These legislative texts form a definition of framework for the categories of works which they rule, according to which a work is considered original if it is the result of intellectual work of its creator, its author own intellectual creation. Most, if not all, of EU copyright law legal texts leave the definition of the concept of author in member states' legislator. The settled case law of the Court of Justice of the EU leaves no room for doubt that the creator of copyrighted works is a human being. The conditions for the protection of software database and photographs and the interpretation of originality as derived from European jurisprudence clearly implies the need for a creator who is a human being, even for specific categories of work such as software. Also, the fundamental EU jurisprudence on the criterion of originality repeats as its common denominator the legislative definition of the EU directives on copyright, however, extending it to all works and developing it conceptually by adding the concepts of creative freedom and personal touch of the creator. In other words, in the EU law and jurisprudence, the creative expression should be based on free and creative arrangements of the creator which lead to the impression of the personal touch or the so-called personal stamp of the creator of the work. Therefore, there will be no originality when the creation of a work is dictated by technical function or other technical or functional commitments that leave no room for creative freedom. Computer-generated works are dictated by technical functions solely and thus lack the originality criterion, the personal touch and the personal stamp of the creator. The Infopack case, as well as the Painter case, are usually mentioned regarding the criterion of originality in the EU law and jurisprudence. The Court of Justice of the EU decided to define originality in a work as a requirement for copyright protection, in the sense that a work must be the author's own intellectual creation in order to be eligible for copyright protection. Dealing specifically with computer-generated works, there is further clarification in the Besbesnosti case, in which the EU court declared that the graphic user's interface can, as a work, be protected by copyright if it is the author's own intellectual creation. All the above mentioned cases ruled by the Court of Justice of the EU make it clear that an author's own intellectual creation clarifies that a human author is necessary for a copyright work. The author's own intellectual creation must reflect the author's personality. Having said that, it is quite clear that in the case of AI-created works or computer-generated works, the fact that the decision and the technical details in the creative process of these works are coming from a machine, not from a human being, and particularly in some cases from mechanical neural networks that mimic biological neural networks, drives to the conclusion that there is nobody as owner of these works created by AI, and there is none in the legal sense of right holder of copyright on AI-created works or computer-generated works. Works created solely by AI and machine-generated works are in the public domain. This definitive conclusion is legally correct regarding the EU legal framework for copyright as well as the continental law area for copyright. In consideration of the Greek copyright law, works created by AI and computer-generated works cannot be copyrighted and cannot even be considered as works in the sense of copyright law because they do not pass the originality test and there is no human creativity in their creation. The application of Articles 1, 2, 3, 4, 5, and 6 of Greek Copyright Law 2121 of 1993 does not allow for any consideration of copyright protection for AI and computer-generated creations. Said provisions of the Greek copyright law consider human beings as authors to be the right holders of copyright. There is no direct or indirect provision in the Greek copyright law in which non-humans can be copyright holders. Therefore, for the Greek copyright law, computer-generated works and AI creations cannot have a copyright holder and are thus in the public domain. In the United States law and jurisprudence for copyright, the standard is set by the Supreme Court case Feist versus Rural, in which the Supreme Court of the US had to decide on the originality of a phone directory containing names, towns, and telephone listings. The Supreme Court famously commented that 100 uncopyrighted facts do not magically change in their status when gathered together in one place, and took the stance that copyright protection can be given to those components of a work that are original to the author. For copyright to exist in a work, the US Supreme Court required a modicum of creativity of the author to be present and proved. Under the standard set by the Feist versus Rural case, ruled by the US Supreme Court, computer-generated works are not protected by copyright because they lack lack of originality in said works since there is no human author to add his or her own intellectual creation and personal touch in the work. There can be no copyright to computer-generated works if there is no human presumption in the creation of said works. No human authorship in computer-generated works means that there can't be copyright, even with the sweat of the brow approach, which was prevalent in the US copyright law before the decision of the Supreme Court in the Feist versus Rural case. Computer-generated works are deemed mechanical and are thought not worthy of protection in the US copyright law and jurisprudence. However, in the case of computer-generated works, if there is a human component that bears originality, then the work is copyrightable. This is an issue to be deemed on a case-by-case basis. The US Copyright Office has set up a voluntary system for registration of copyrighted works. Though the law does not require any formality for the subsistence of copyright, registration of copyrighted works seems to be necessary for the enforcement of copyright in the US. In said system for registration of works, the US Copyright Office clearly declares, quote, will register an original work of authorship provided that the work was created by a human being, end of quote. In Australia, the Copyright Act of 1968 sets the requirement for authorship to be strictly tied to the existence of a person. Computer-generated works are not protected with copyright in Australia. Australian jurisprudence of the High Court, such as in the ICE TV case, which reversed the ruling in the case Desktop Marketing versus Telstra case, indicates that there is no copyright where there is not enough skill and labor in the expression of a work. A similar decision of the Australian High Court is found in the case Telstra, where the judge goes as far as to decide that phone directories involved in the litigation of that case were not original because authors of those works had not exercised independent intellectual effort. Another case of the Australian jurisprudence which denied copyright protection for computer-generated work is work in which there was no human authorship is the case ACOX versus UCorp. The Australian judge ruled that the resulting output in said case did not have copyright protection because the source code in the case ACOX versus UCorp had been generated by the system. It was computer-generated work. And in such a case, it had, as such, the work had no single human author. By being generated by a computer program, the claimed work in this case was lacking originality and consequently, it could not have any copyright. The decision of the Australian Court of First Instance in this case was appealed, but the ruling of the first instance sustained in the Court of Appeal. The Australian Federal Court decided that the code had not emanated from a human being, and therefore it was not an original work in the copyright sense. In China, courts have applied some form of copyright protection for AI works. Chinese jurisprudence in the case Tencent versus Yingxun ruled that the article written by an AI program has copyright protection. The article in the case Tencent versus Yingxun was written by Tencent's Dreamwriter AI writing robot. The Chinese court decided that the article in the case, though it was written by Tencent's Dreamwriter AI writing robot, which means that it was found that there was no human authorship, it was determined by the personal selection and arrangement of the plaintiff's team, thus it was eligible for copyright protection. There is also another case of Chinese jurisprudence, the case Fei Lin versus Baidu, in which the court thought, though it stated categorically that machines cannot produce copyright works and that human authorship is vital in determining whether a work is subject to copyright protection, it afforded some kind of protection to the work, in this case because of the investment that went into the creation. In said case, the Chinese court recognized that some form of right arises from a work generated by a computer, even if this is not to be given full copyright protection. I have left at the end some thoughts regarding the British law and its ruling for computer-generated works. As you know, the UK is no longer a member of the EU, and the British law is not continental law. Section 9, paragraph 3, title authorship of work of the Copyright, Designs and Patents Act of 1988, that is applicable in the UK, states the following. In case of a literary, dramatic, musical, or artistic work which is computer-generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Also, section 178 defines computer-generated in relation to a work, meaning that the work is generated by computer in circumstances such as there is no human author of the work. Similar law provisioning to the British section 9.9 paragraph 3 of the CDPA of 1988 for the protection of computer-generated works exists in very few countries, namely Ireland, New Zealand, India, South Africa, and Hong Kong, all of them being affected in their legal system by the British law since they were ex-British colonies and have history of relation to the Commonwealth of Nations. Having the above ruling and definition in mind, it seems that the UK law protects computer-generated works by copyright. The British law, which confers copyright protection for computer-generated works, has been criticized for being ambiguous, especially regarding who is copyright holder, eventually under the existing phrasing of section 9 paragraph 3 of CDPA. Is it the programmer of the artificial agent or the user of the program in the computer which produces the computer-generated work? I think that section 9 paragraph 3 of CDPA answers the questions, do AI works have creator in the legal sense of right holder of copyright? The answer is yes, according to the British law. But does not clearly answer the question, who is the owner of works created by AI? Consideration that the British law offers better solution than the option of treating works created by AI and computer-generated works as works in the public domain has yet to be proved right. it has been supported that Section 9, Paragraph 3 of CDPA is the best option in the market for computer-generated works because it brings certainty to an uncertain legal area, is implemented internationally in those ex-Commonwealth countries which have similar legal provisioning to the British law, does not require any change in the copyright law regarding the originality requirement for assigning copyright to the author of a work, is consistent with existing copyright law and the case law, allows for judgment on the case-by-case basis regarding who is copyright holder of computer-generated works. Are these claims right? It has yet to be proved. I wonder, though, why do we need to have copyright protection for works created by AI? Why things would be better if we assigned an absolute right such as copyright, or perhaps devised and assigned a new sui generis right to computer-generated works and AI creations? How can the reasoning of Infopack case in continental law and the reasoning of Face versus Rural case in the US law, or the reasoning of the ICE TV case in the Australian law from one side, and the reasoning of Section 9, Paragraph 3 of CDPA, how could they coexist in the same legal system? If there is no authorship in the creation of a work, there is no author skill and judgment in the creation process of a work, and consequently, there is no originality in the creation of a work. How is this fact in sync with the international conventions on copyright? If we acknowledge copyright protection for AI works and computer-generated works, there are moral rights concerns since the author's personality is expressed in a work, and there is no author personality expression in computer-generated works and AI creations. And finally, what are the necessary arrangements for the creation of the work by computer-generated and AI creativity, and what arrangements are not necessary for said creation in said creativity? Though Section 9, Paragraph 3 of CDPA in the British law has existed in the market since the late 1980s, there has been only one case in which the court applied the computer-generated work provision. This is the Nova case. Suppose that there was indeed a need for copyright protection of AI works or computer-generated works, then we should consider whether this absolute right allocation to works created by computers, even though the use of AI or not, could stifle creativity. We should consider if this allocation could stifle creativity. Having that consideration in mind, it seems fit to me that the law should require as a default the non-voluntary licensing of AI works or computer-generated works which are copyrighted works. The non-voluntary licenses allow use of works in certain circumstances without the authorization of the owner of rights, but require compensation to be paid in respect of that use. Such licenses are called non-voluntary because they are allowed in the law, and they do not result from the exercise of the exclusive right of the copyright owner to authorize particular acts which are taken within the private sphere of action of copyright users. The non-voluntary licenses for computer-generated works could alleviate the cost of trading copyrighted and licensed through them of AI works or computer-generated works, which could be significant. Granting monopolistic property rights over AI works or computer-generated works is less efficient than enabling through the default non-voluntary licensing the use of them by everyone. Thank you very much. This is the end of this presentation. I dedicate this presentation to Professor Dionysia Karilingou, my professor in Athens Law School. Thank you very much.
Thank you very much, also, Dr. Marinos Papadopoulos. It was an overview of the legal, the laws in different parts of the world, but also the skepticism about copyright protection of AI. It's something new, and I guess the legal community has not decided yet. So we quickly go to our next speaker, Dr. Maria Daphne Papadopoulou. She's a copyright expert working as a freelance attorney, but she's currently the acting director of the Hellenic Copyright Organization, and she has an extensive law drafting experience and also has written several contributions in books and articles. The topic of her presentation about AI again is training AI in libraries, copyright issues. That's important. So the floor, Daphne is yours.
Yes. Hello. Good morning or good afternoon, I would say. Thank you very much for the invitation, the organizers. Thank you also for the words about me. Thank Marinos that he actually opened the discussion about AI. We share the same name, but actually we are not related. We belong to the big family of Papadopoulos in Greece. And yes, so I know this is a very difficult subject, and it's difficult also from a legal point of view and from technological point of view. So bear with me, I will try to say it as simple as possible, and I will try to tackle the copyright issues regarding AI, but also from the library's perspective. Because during the AI, all the circle of AI, there are a number of copyright issues that are involved. One very important is the one that Marinos has already mentioned, who is the author? Very, very important. I'm going to see the second major point, because there are also many other ones, regarding the training of the AI, which is also very important, and maybe a little bit you face this a little bit earlier in the life cycle of AI. And having said that, I will put the timer. Now the time starts. I have the 20 minutes. So what is AI? Probably most of you know, or you don't know. I'm not going to explain this in a very technological point of view. AI is a disruptive technology that has experienced a lot of development the last decades, and actually has become a completely game changer, and it's changing our lives in daily lives. And in a nutshell, I would say AI is a solution that is implemented as a tool for many uses, and generative AI is capable of producing actually new original, I will also say if it will be original, new original creation, text, videos, images. Following by the instruction given by the users, the prompts. So those creations are not spontaneous. Only the human being is spontaneous. These creations are created behind the scenes. There is a software, and this software implements an algorithm. The algorithm has been trained using huge amount of data and copyrighted, most of the times, protected content. So through this training, is able to generate predictions. This is what the AI does, is generate predictions. It's not created by itself, but based, because it's fed, it's trained with this already existing knowledge, it's able to make the predictions, and this is the way that the new creations are there. So this is an association is being made between the input text, the prompts, and the already pre-existing knowledge. With this association, the AI gives the output, and according, of course, to the instruction given. The better the AI tool is, the better the output fits the input. And more importantly, the better the input, the better the output. Or if I put it another way, garbage in, garbage out. So let's see, this is about AI. Let's see how is AI important in libraries. Probably most of you already know this, just to make this AI perspective for libraries. You can make collection of machine-readable data and describe them at scale. You enhance or create metadata with AI. You can discover knowledge. You can literature. You have review of literature. You can support text data mining. You support institutional data science community. You can, with AI, of course, generate text and images. You can have chatbots, either library-specific or institutional chatbots, and many other things. I don't want to tie with this, but let's put it in a simple way. The libraries can use AI for themselves and can help others use AI. Okay, AI libraries. But what is the training of AI models, and what is the connection to copyright? this is, I will go a little bit, maybe I will change the order. The training, as I have said, the training of general purpose AI models requires access to vast amounts of text, images, videos, and other data. This is the workflow. I'm not going to go through this, but during this workflow, this is for sure that certain exclusive rights of the right holders, of authors, they're going to be infringed. Rights of reproduction, extraction of database, communication to the public, making available to the public, all these rights during this life cycle of AI could be infringed. I'm going a little bit, I'm changing the order. Probably I should speak to you first about the text data mining exceptions that they are in the directive and also incorporated in the Greek law. But I will speak to you about the AI Act. I am almost sure that you have heard about this. And there, in the preamble, it's a very nice, let's say, structure how the whole thing is involved with copyright. So what is this mentioned there? Let's say for the training of this large AI models requires access to copyright-protected content. You need text data mining techniques, we will see what's this, in order to analyze this content. For the use of the content, you need authorization, if it's copyright protected, you need authorization of the right holders, unless copyright exceptions apply. And there are some very important exceptions, text data mining exceptions, that actually is the basis in order to train the AI models. So if there are these exceptions of text data mining apply, no need of authorization. Very, very structure just to realize how is involved. A small parenthesis, because important, it's a little bit illegal, but okay, I am a lawyer, I have to say this, that AI Act, because it's very important, it's a lot of discussion is being about AI Act, it does not apply to AI systems or AI models developed for the sole purpose of scientific research and development. In the AI Act, which is not a copyright act, is a public instrument law, but imposes very big fines, so it's important. This doesn't have to do anything when this AI model is only for scientific research. The moment, of course, that's making profit out of this, then AI Act applies. Of course, in the AI Act, they're saying that they are voluntarily encouraged to comply with the additional obligation of AI Act. I'm closing the parentheses. Let's go now very quickly to see these two exceptions for text data mining. At the beginning, there was planned to be only one, only for scientific research purposes. During the negotiations of the directive, there was a lot of pressure to have also a general exception. So not only for scientific research and for specific beneficiaries, but for a general exception because they realized, although generative AI has not been in a spot, it was only AI, they realized the importance of this. So indeed, by the end, we had two exceptions, and that's why it's explained. First, we have the scientific research, the more specific one, and afterwards we have the more general one. It's supposed to be the other way around, but because it was a negotiation like this, at the beginning it was first we have the specific and afterwards the general one. Just also not to lose why we're discussing about this text data mining exceptions, because you say, I don't care. There is important, these exceptions, because you give the possibilities to libraries to train AI models without paying anything to right holders and without getting authorization. So they are important, and to have to know at least to know how this apply in at least the basic notions. What is this Article 3 of the Digital Single Market Directive? It's actually, it gives the possibility to specific beneficiaries, we're going to see who they are, to exercise this text data mining only for scientific research if they have lawful access to the works they want to mine. This is the three basic notions, and the exceptions is not all the rights of the right holders, but majorly to the rights of reproduction and the sui generis database right. It cannot be overridden by contract, It's mandatory for all the member states in order to implement it. It's not subject to compensation. The member states cannot say that someone has to pay something. And it's subject to the three-step test. Is a general rule, very legal. I'm not going to talk about this. Beneficiaries, research institutions, cultural heritage institutions. Cultural heritage institutions very clearly are mentioned publicly accessible libraries. But even the research organizations also are included university libraries, because in the research institute organization is every entity that the primary goal is to conduct scientific research or educational activities, services, involving, of course, always scientific research, very importantly, on a non-for-profit basis, or if they do have profits, they reinvest these profits in the scientific research. So it's mentioned also the universities, including its libraries. So also the university libraries could be a research organization and take benefit from this exception. Scientific research, both natural and human science. So a logical question, when libraries use text data mining for their own purposes, could that be covered by the meaning of scientific purpose? Yes, most probably yes. And to this conclusion, also it helps the fact that we have a very, very interesting case. I don't have a lot of time, and probably you don't care about this, but for the legal community it's very important. A case, Kneske against Lyon, is a German case that was about a German photographer that he realized his photos that he was uploaded in a stock website. They were used from a lion. It was a non-profit organization that is training and creating data sets. It's used to train these data sets. And so the photographer said, I'm sorry, you didn't take my permission, you didn't pay me. He went to the court. And we had the decision. The decision is appealed, so we'll see what happened in the next months. But it was interesting, and I mentioned this case here, because it gave a very broad, very wide interpretation to the scientific research notion. And they said, you know, scientific research is not only when what you're doing, you are gaining knowledge, but even if it's a preparatory steps in order to gain knowledge, this is, again, scientific research. So it gave very wide interpretation. It's giving, let's say, more possibilities to take advantage of this exception. Second, very, very important, lawful access. And I think this is something that's creating the more problems. In order for this beneficiary to use this text data mining exception, has to have lawful access to the works. The lawful access, let's just to mention, it's the notion is for the very first time we see it in a directive, because till now we had the lawful use. Now the EU legislator, I don't know if he did it on purpose or it was by accident, he used a different notion. And you know, for the scholars, this is like, as we say in the Greece, butter on the bread in order to start all this interpretation. Why did they use a different notion? A lot has been written on this. I won't mention it, but just to making a small asterisk. So what's lawful access? We have some help from the preamble in the directive. They say lawful access if you have an open access policy. I think all of you know what the open access policy is. If you have actually this scientific journals, academic journals, peer-reviewed research literature that's actually online, free of charge and accessible without any registration, it's an open access policy. If you have any copyright restriction, and this is really open and accessible, then it's something so lawful, so you have lawful access. And you can use this work in order to text data mining. You have also, if it's freely available online, the content. What does it mean? Actually, if you have, this excludes content that is behind a paywall or protected by any technological protection measure. Or it's through contractual arrangements. That means subscription. I think this is straightforward. If you have paid a subscription, then you are allowed to use this work in order to mine, to do this text data mining things. or through other lawful means. Okay, and this starts the discussion. What the other lawful means could be? I was trying to think what would be something for in libraries would be useful, what could be other lawful means. It could be legal deposits. Most of the libraries work as repositories and do have, let's say, these legal deposits. Is this content, can the library use it in order to do this text data mining thing? I was really searching to find a solution if something has been written about this. Nothing has been written, at least after the DSM directive. But for me, very logical, I cannot see a reason not to be used since it has lawful access to this content. So if no other restrictions applied, and I mean mostly about technological protection measures, this is something that also can be used in order to do the text data mining. Grey literature. Also, grey literature is something that could be used for text data mining since it's something that is open to the public. It's not subject to any commercial restrictions or arrangements with the publishers. So if it's open to the public and free, available online, then also can be used in order to do this text data mining. And Creative Commons. Okay, this is something, it's a little bit tricky. If you have the use of a Creative Commons licensed work for text data mining purposes is covered by the exceptions. Just to put another. If you have an exception, then the Creative Commons license is not triggered. You need to have this, you need to take advantage of this Creative Commons if no exception apply. Because the whole notion, the whole logic behind the Creative Commons is not to create amendments, but on the opposite, in order to make the life easier, to make easier to use a work under the conditions that the Creative Commons license imply. So this is something, I'm not going. I have 5 more minutes. We're at 20. But if I were, I will say for 2 minutes. I will make it very, very quick. Again, I'm not going to go through this infographic, but just to show how easy is your life, in order to understand how the text data mining can be, how the different kinds of text data mining possibilities exist. So you see that the lawful access, although it's not supposed to be like this, but it could be like a formal reservation of the right to text data mining. So if you have access, this implies text data mining. No access implies no text data mining. They have some other also provision that you have to store it in a very safe way. I'm not going to go through this. But it doesn't add this possibility that it gives to the right holder to restrain the access to his content. It goes a little bit further, because also in another paragraph of this Article 3 gives the possibility to the right holders to apply measures to ensure the security and integrity of the networks and databases. So they give them the green light if they want to have to make it a little bit more secure in order to have the access. And this could to take a lot of different examples that actually restricts the access to this to the content. I'm not going to go through this. Or to have an APIs in order to be very technical and simple, to allow only a certain number of requests or certain lengths or complexity of queries. And also, lastly for this, just we have the technological protection measures that can also apply in order, this balance is very, very difficult to manage, to have protection of the technological protection measures and at the same time to enjoy the text data mining exception. It's very, very difficult. And although there is a specific mechanism also in SWINT, in the InfoSoc directive, this, because there are plenty of studies that shows that this kind of this balance is very difficult, because it's very difficult if there's a technological protection measure on work that it doesn't allow the beneficiary of exception to take advantage of this content. It's supposed to be some mechanism in order to be able to take advantage of this, so the right holder to take back, let's say, the technological protection measure, but hold the system, it's not so effective. This is a very interesting decision because, but now I'm not going to analyze it. It's very difficult, but let's say it gives maybe a solution to a problem. So this is the K21 report saying the findings that it's a little bit how difficult the situation the technological protection measure is. And also very quickly to say this was the specific exception. There is also a general exception. If for any reason a library cannot take advantage of the Article 3 because there is an economic for-profit element, so it cannot take advantage, there is also always the Article 4. That's a general exception. Everyone can take advantage from this. Also, you need a lawful access, but there is something that is not in Article 3, opt-out. Very big discussion about the opt-out, because actually this gives the right holder to not to allow to text undermining their works. Huge discussion how this opt is going to be actually exercised. It has to be standardized in order to have legal certainty for both right holders and users. Conclusions. Okay. Very quickly, it's possible to train AI in the libraries. Second, from copyright perspective, it's a difficult puzzle to solve, but still possible. 3, in order, you have to avoid to have a situation you are going to mine more laws than you mine data. 4, we need some refinements in national law, but most importantly, some guidelines to know what libraries are allowed to do. And because they say one of this nice title, say Voices and Vision for a Legislative Change. Legislative change concerning text undermining is going to be at least till the end, I think 2026, cannot be touched. So we need to find another ways in order to make this happen, because of course there is a lot of legal uncertainty in these kind of things, and something that really has to work, because it's not something theoretically, it's really, it bends the knowledge and all this, the AI, it's very, very closely intervened with the innovation, and this is something all we have to look. And still we have to consider, though, finally, when transitional phase, we are very much dazzled from AI and also at the same time puzzled. It will work, it needs some time, and I think we will find the right solution and the right to all these problems. Thank you.
Thank you, Daphne. You explained the AI Act for libraries and the implications and the beneficiaries, but also the legal constraints, and the discussion is going on. So we have for the next, our next speaker is the librarian. We had the lawyers part, now we have the libraries part. It's Dr. Roxana Theodorou, who is the information scientist, works at the Library of the Hellenic Parliament, and was involved in the implementation of the e-reading room at the National Library of Greece, and also worked at the Hellenic American Union and several other libraries. She will talk about censorship and AI, or how the Ministry of Truth is finally open for business. So, Roxana, the floor is yours for the next 15 to 20 minutes, because we are running out of time.
You're not helping. I'll try to be brief.
Thank you.
Good day, everyone. As you've heard, my name is Roxana Theodorou, and basically, I'm a librarian, right? Books have been the better part of my life since I can remember myself. And when I was a child, I had a great and almost unhealthy, to be honest, fascination with crime novels and dystopian fiction. Looking back, I think that what gave me the most pleasure was the moment that I finished the story, closed the book, and resurfaced in the safe, boring, everyday world. As an adult, true crime podcasts and tech advancements are my guilty pleasures. Nothing has really changed, apart from the fact that those subjects now make me popular in, complete distinction to the high school self that I used to have. Many of the ideas that once felt exaggerated, impossible, or like the wild creations of an overactive imagination, things that actually thrilled me as a child are now gradually becoming reality. Consider 3D printing, video calls, jetpacks, driverless cars, robots, cloning, virtual worlds, exoskeletons, space tourism, targeted advertising, mass surveillance, synthetic meat, creative AI. Obviously, from all the things mentioned, artificial intelligence, although not yet creative, is probably for me the most magical, exciting, and important technological leap humanity has ever taken, right next to the wheel, the printing press, and the internet. However, like everything else, it comes with a price. Censorship and propaganda have long been tools for controlling communication, dating back to the classical antiquity. The invention of the printing press is in the early modern period amplified the importance of censorship, initially driven by the church and later by state authorities. Efforts to secure press freedom began in the 17th century England, achieving significant success by 1695. However, countries like France and Germany lagged behind. Progress towards freedom of expression often faced setbacks. In the 20th century, emerging media such as film, radio, and television also came under censorship, with modern totalitarian regimes heavily suppressing these channels. However, until now, the tools used to enforce guided information were crude, violent, and to an important extent, very, very obvious. During the 1967 junta in Greece, for example, everyone knew that the government controlled the media and that official news outlets could not and should not be entirely trusted. Even the supporters of the regime admitted the freedom of speech was restricted. The same goes for every dictatorship around the world. At the same time, it is important to remember that not only totalitarian regimes wish to control the narrative. Democratic states as well have the power to subtly, or not so subtly, affect how facts are presented. It would not come to anybody's surprise to learn that the history of the Greek Revolution, for example, is described in completely different terms in Greek school books and in Turkish ones, or how the Vietnam War was reported in American newspapers compared to the Vietnamese ones, and so on and so forth. One could argue that possibly the interpretation of the facts may be different in these cases, but the facts themselves remain. After all, in the words of Daniel Patrick Moynihan, everyone is entitled to their own opinion, but not to their own facts. The fact that Moynihan himself was for some time Nixon's advisor makes this remark, even more iconic, but let's not overanalyze this. But even so, there were times that facts were invented to support a cause. Take the Protocols of the Elders of Zion, being one of the most famous fraudulencies in history. And throughout history, still, people, for the most part, insist on debunking fake news, fabricated documents, forgeries, and outright lies. So what makes this point in history more frightening? What is the difference? The internet has transformed the scale of influence, rendering old rules obsolete. National borders once generally limited government power, and corporate influence was confined to ads and political contributions. Today, with information crossing borders freely, artificial intelligence enables advancements like improved healthcare and personalized experiences, but also grants governments, corporations, and individuals unprecedented tools to shape and censor information. Freedom of speech now hinges on algorithms and data models driving the internet. AI-driven censorship is already happening, sophisticated, often invisible, and alarmingly effective. This presentation examines 4 examples of these tools, revealing their subtle yet pervasive impact on human communication and the risks they pose if left unchecked. Let's start with social media content moderation. Social media platforms like Facebook, Twitter, X, and YouTube have become global town squares, allowing billions to share their opinions, ideas, and stories. With such enormous volumes of content generated every second, AI systems are used to enforce policies on what is permissible. These systems, however, do more than prevent the spread of illegal or harmful content. They often end up silencing legitimate speech. AI-powered algorithms can review content in real time, flagging posts and videos that violate terms of service. For instance, AI can be trained to detect violent images, hate speech, and offensive language, leading to content removal or account suspension. In principle, this is beneficial in maintaining a safer online space. But in practice, it can lead to a troubling level of control over what users actually see. AI lacks the nuanced understanding of context that human moderators might possess, and mistakes happen frequently. Content expressing political dissent or even discussing sensitive historical events can sometimes be mistaken for extremism or hate speech and thus flagged and removed. The potential for abuse is significant. The Chinese government, for example, that controls social media platforms and AI technologies, uses a combination of automated filters and human moderators to monitor and restrict content that could criticize the regime or support free speech movements. The case of how social media platforms automatically filter out words like Tiananmen Square demonstrates how AI tools can enforce censorship on mass scale, eliminating mention of politically sensitive topics entirely. In the context of a nearby ongoing war, details of which I'll avoid for obvious reasons, and you see the self-moderation going on here, official government accounts from one side have faced accusations of sharing fake, misleading, or incendiary content. Despite the provocative nature of these posts, they often remain online, raising concerns about leniency or selective enforcement of platform rules when it comes to state actors. At the same time, while content linked to the armed forces of the opposing side circulates freely, posts by activists and civilians documenting explicit human rights abuses are often flagged and removed. This inconsistency highlights the biases and challenges of applying content moderation policies impartially during conflicts, further complicating efforts to ensure fair and balanced information flow. Another tool in AI censorship toolkit is automated fact-checking. Fact-checking itself is a necessary endeavor in combating misinformation. After all, as librarians, this is basically what we do. But its automation raises important concerns about who determines what is true and what is false. Currently, AI fact-checking tools are used by platforms like Facebook and Google to review and flag questionable content. However, automating fact-checking introduces an element of control over what is deemed acceptable information. Fact-checking AI systems function by scanning articles, videos, and social media posts for content that contradicts established narratives or factual consensus. While this can help prevent the spread of conspiracy theories or false information, it can also silence legitimate discussions on complex topics. For instance, during the COVID-19 pandemic, fact-checking AIs were deployed to monitor health-related information. While this helped curb misinformation to an extent, it also silenced some dissenting voices from the scientific community who questioned certain health policies or the efficacy of certain measures. Recently, on the other hand, Elon Musk, through his platform X, has played a key role in amplifying misinformation about critical battleground states that influenced the outcome of the US presidential race. According to a report by the Center of Countering Digital Hate, at least 87 posts from Musk this year have spread election-related claims that fact-checkers, human fact-checkers, deemed false or misleading, collectively garnering 2 billion views. Musk leveraged his control over the platform to amplify false narratives while suppressing opposing perspectives, a kind of reverse fact-checking, if you will. Musk's penchant for conspiracy theories, combined with his immense wealth, influence, and a highly loyal following, creates a dangerous dynamic. By using his platform to maximize the reach of his own posts and enforcing arbitrary moderation rules, he yields disproportionate power over public discourse. This approach undermines efforts to maintain factual integrity online and raises significant concerns about the broader implications for democratic processes and free expression. The issue here is not that fact-checking should be abolished, quite the contrary, but it should be made clear that AI systems are not neutral entities. They operate based on the training data and rules programmed by humans, which means they reflect the biases and values of their creators. The risk of those systems is that they could intentionally or not censor alternative viewpoints, stifling debates on complex issues where consensus is neither absolute nor straightforward. As AI fact-checking becomes more prevalent, we may need to reconsider the ethical implications of allowing machines to dictate what information is deemed true or what false. Predictive policing is another area where AI serves as a powerful censorship tool, albeit in a more indirect way. By using vast amounts of data, AI algorithms can predict and monitor potential criminal behavior in specific areas. While the intention is to prevent crime, these systems also open the door to new forms of social and political control. In regions with stringent social control, predictive policing is used not only to prevent violence, but also to control populations deemed at risk of dissent or rebellion. Take, for example, China's use of predictive policing technology in its Xinjiang region, where AI-powered surveillance tools are used to monitor and suppress the Uyghur population. Here, predictive policing tools can monitor people's digital footprints, such as their social media activity, online searches, and even interactions with religious content. Based on this data, the system predicts who may engage in dissent, even if there is no actual crime committed. This allows authorities to suppress or censor content that might inspire resistance or organize people around the cause before it has a chance to spread. Predictive policing raises the terrifying possibility of preemptive censorship, where information deemed potentially dangerous is silenced before it reaches a public forum. Even more invasive is China's social credit system. A government initiative decided to assess the trustworthiness and behavior of individuals, businesses, and institutions. Introduced in the early 2000s, it leverages big data and surveillance technologies to monitor various activities such as financial transactions, legal compliance, and even personal behavior. This system assigns scores or ratings, let's say, which can affect access to services like loans, transportation, education, and even employment. High scores can grant privileges such as streamlined bureaucratic processes or better loan terms from a bank, while low scores can result in penalties like restricted travel, reduced social services, or public shaming even. In an era when AI surveillance can predict behavior and preemptively stop dissent, censorship becomes not just a means of suppressing existing content, but of preventing the very creation of content that could lead to social and political change. Earlier this month, Google announced the launch of Polygemma 2, a freely accessible AI model designed to recognize emotions. While such a technology is probably largely prohibited under the EU law, regulatory frameworks remain ambiguous. Consider the implications: an employer using this tool to gauge employees' dedication, governments monitoring citizens for compliance, or authorities analyzing an asylum seekers' emotions to identify potential threats. Given the inherent complexity of accurately interpreting emotions and the significant behavioral changes people exhibit under stress, this technology could easily result in discriminatory outcomes. AI technologies have sometimes been utilized to create or alter representations of past events, sparkling ethical concerns about preserving historical authenticity and memory. For instance, generative adversarial networks, GANs, have been employed to generate historical-looking images, such as producing satellite-style visuals based on old maps. While these applications often serve constructive purposes like urban planning or historical research, they illustrate how AI can produce content that mimics historical artifacts without being genuinely authentic. AI has also been used to reinterpret historical narratives, sometimes distorting past events intentionally or unintentionally. For example, AI models trained on biased data can highlight certain viewpoints, while ignoring others, leading to skewed interpretations. Additionally, AI-generated content like deepfake videos or altered texts can convincingly fabricate events, enabling the deliberate rewriting of history for malicious purposes. The implications for historical research are significant. If AI is already generating historical-style images, how soon before it creates fabricated historical documents? AI-driven censorship tools are poised to become more powerful and pervasive in the future. With advancements in natural language processing, AI will soon be able to analyze text with greater context and nuance, raising the potential for even subtler forms of censorship. Imagine a future where AI can analyze an entire body of written work, then decide whether a narrative aligns with approved messaging. This could allow governments or corporations to subtly adjust narratives by filtering content that contains specific themes or biases, effectively nudging public opinion without the users realizing. That exactly was, after all, Winston Smith's job description at the Ministry of Truth. We may also see AI being used to develop echo chambers, where users are systematically exposed only to certain types of information. AI can already personalize content feeds, and if deployed to favor specific political or ideological messages, this could lead to a populace that only sees curated headlines. This is especially concerning given that AI algorithms are already fine-tuned to show us what we want to see, leading us into digital battles where alternative viewpoints are almost inaccessible. In this era that is increasingly shaped by artificial intelligence and algorithmic decision-making, information scientists have a critical role in combating AI-driven censorship. These professionals are uniquely positioned to ensure equitable access to information and to advocate for transparency in how AI systems filter, moderate, or suppress content. By understanding the biases inherent in both historical data and algorithmic design, they can identify patterns of exclusion and work towards mitigating their impact. Their expertise in curating balanced, representative collections is invaluable in creating datasets that counteract systemic bias in AI models. Information scientists can also function as mediators between AI developers and the public, promoting ethical principles in AI governance. They can advocate for algorithmic accountability by documenting instances of AI censorship, analyzing their causes, and pushing for better transparency standards. Additionally, they can contribute to developing AI literacy, helping communities understand how algorithms influence the accessibility of information by championing open access principles and supporting decentralized platforms. Finally, librarians and archivists can play a crucial role in curating the records of the past, which positions them as vital actors in preserving and providing the authenticity of information in the AI era. Their work involves evaluating, organizing, and safeguarding historical documents, ensuring that they may remain accessible and verifiable. This expertise is particularly relevant as AI systems increasingly shape narratives by determining which content is amplified or suppressed. As AI tools become increasingly intertwined with content moderation, fact-checking, and predictive policing, the potential for censorship becomes less a theoretical risk and more a present-day reality. The future we face is one where information control could become near total, driven by algorithms designed to shape public discourse and limit dissent. Censorship is no longer about burning books or banning newspapers. It's about influencing algorithms and manipulating data streams. To prevent AI from becoming the ultimate tool of censorship, there is an urgent need for transparency, accountability, and oversight in AI development and deployment. AI technologies used in content moderation and information management must be transparent and open to public scrutiny. The EU's AI Act is certainly a good start, but it's not enough. Ethical AI frameworks that balance the need for safety with the right to free expression must become standard practice across industries. The fight for free speech is entering a new era. As we face the rise of AI-driven censorship, the tools we choose to build and the regulations we enact today will shape our future as an informed, empowered, and free society, or a controlled and censored one. The choice is ours, and the time to act is now. Thank you.
Thank you, Roxana, for the other side of AI, the censorship side. We quickly go to Dimitris, Dr. Dimitris Kouis, who is an associate professor of the Department of Archival, Library and Information Studies at the University of West Attica, and he plays a pivotal role of scientific coordinator in Project ILSAS, which is aimed at upgrading the information infrastructure of the 22 academic libraries in Greece. Dimitris will, the title of his speech is Sustainable Models for Leveraging E-books to Foster Innovative Approaches in the Dissemination and the Representation of Scholarly Knowledge.
I'll try to be as fast as possible.
Yes, please. Yeah,
Can you hear me?
Yes, of course.
Okay. So, I mean, the setup here is a little bit difficult, so I will stay here because I cannot see from far away. Also, just to be... No, I'm fine. Just to be clear, I mean, I will not be tempted to talk about the Greek reality, because Greek reality is something very strange. It's a unique paradigm in worldwide level. As far as concern how we manage scholarly knowledge in the form of at least digital periodical print journals, and of course textbooks or scientific books. Although we have very good relationships with the Greek, with foreign publishers, and we have contracts, and we work e-books and of course periodical journals and whatever in electronic format, does not apply with the Greek publisher. But as I said, I will skip this part because what I would like to give you is an overview of how a sustainable model also in this field could work for us also. I mean, everything changed by the introduction of the internet. I mean, maybe it's the biggest discovery after electricity. There are many people try to find the analog in terms of technology development. So the internet changed everything. So, I mean, two examples here, the television to the internet. We have the dual screening model. I mean, we watch TV and at the same time we have our mobile phone and move around, let's say, go around the information. And of course, newspaper to social media. But I assume that you already know that. Of course, the transition, I will skip doing the analysis. Yes, of course, the transitions, I mean, we are from the world of libraries, we need that we have a transition from print collections to digital ones. At least for the journals, this is total. I mean, back in 2000, this started. I mean, we cannot imagine our world without electronic journals. And you have also to realize what came with this transition. We have now collection, we have, let's say, infrastructure for searching, we have also tools for citation indexes, and all this technology came with this transition. I mean, it was possible. I mean, these are only some of the aspects. You have to realize that the transition to electronic journals also affected the way that we use them. I mean, it is considered that 50% of the budget of the income of big publishers comes from data mining, not subscriptions anymore, because they use all this stored knowledge and they invest on techniques how to analyze them. The same applies in academic textbooks, but in a more slower pace. There are a lot of things to be done there. So, I mean, we cannot, we have to recognize that this development underscored the transformative role of technology in reshaping both the medium and the methodologies for the dissemination and utilization of scholarly knowledge. Here are some examples about these new forms of content. We have multimedia content, images, videos, whatever. We have the ability of execution of code, not only content multimedia, but I mean, we can encapsulate, integrate into the book the ability to run code, which means interactive figures, let's say simulation, whatever. We have links with external sources and content adaptation and personalization. I mean, we have the ability, the technical ability to adapt the content according to the needs of the users, the learning needs, and also in special case like disability or visual or hearing disability, we can do many things now. And of course, a new trend is that we try to organize the content in a way that we are promote educational resources for micro-learning or for reuse. I mean, this is another aspect. And users from the textual representation of the knowledge, now they are moving to this new form of the presentation of the knowledge. I mean, we have to consider all this because the next, okay. what I'm trying to be as fast as possible. So, I mean, apart from the, let's say, the content changes, we have also changes in various areas, like how we create content. We have these now collaborating environments. And of course, how we evaluate the content. I mean, we have all this open peer review or different evaluation methods, or even now users can evaluate the content themselves. We have new ways of how we access the content, the new encoding formats, and how we distribute the content. Apart from the traditional distribution from the publishers, we have also the open access models that they apply now. Changes also apply in the intellectual property and access rights management. I mean, it is unclear to me still, but I mean, it became more clear from the previous presentation what applies with AI and the use of books in learning, in language learning models, whatever is this. We have new funding models for content development. I mean, apart from traditional publishers that they are funding the publication, now we have many initiatives from universities or from the state to promote or to, let's say, fund the creation of e-books. And of course, we have issues like the long-term content preservation, the impact of artificial intelligence, and of course, integration with other systems. What I'm trying to make it here clear is that I will go to the second remark. It is immediately apparent that an electronic book in the context of scholarly knowledge is not a PDF version of the printed book. We have to forget that. And at least in the scientific knowledge, we don't consider e-book the PDF version or the scanned version of a book. It's something new. And we have to realize that. And of course, these have many implications. And the first implication is the cost. Creating an e-book for scholarly communication, for scientific knowledge, is much more expensive. We also have to understand that these changes affect the whole cycle of book creation, accessibility, of authoring, dissemination, and all of this. I will skip these. Here is an overview of, of who is affected by all this, who participates in this cycle. We have the authors and all the related professions. We have the publishers, providers, global distributors. We have the meta-publishers, like big, let's say, e-book support platforms. We have the university and the research centers, and of course we have the governments or all the public entities or private entities that they are in this cycle. And of course, in the other side, we have students, faculty, professionals, and general public, and libraries. The libraries have a dual role. I mean, they participate also in the producers in some cases, or they should. And this is the factors that we should consider in order to understand or to take into account when we propose changes in order to have this sustainable model. I will not go through again all of these factors because we already analyzed some of them. They are related to the technology. They are related with the legal and economic factors. And of course, something that we didn't analyze a lot in the previous slides is those that they have some kind of relation with human or social factors, like the technological familiarity of the users, like the reading and learning models and experience, the spatial accessibility needs, the economic constraints, and also the linguistic constraints. So, currently, the available of textbooks and in general scholarly knowledge is limited, the portion of free textbooks or let's say even for the open access journals is considered very, very low. And this creates an imbalance, okay? And also, especially for students and libraries and universities, it puts a lot of effort, press to their, for their economics, for their budgets, etc. it is unclear how these pricing policies work, and it is not transparent. I mean, those that they are related with budgeting in libraries, I mean, they always have to deal with a new setup, like subscription model, hybrid models, transformative agreements, and they don't, I mean, it's not clear how this model works and who gains most of the profits. And of course, there are issues about intellectual property rights. I mean, now with the increased use of artificial intelligence, I mean, even for books that they are accessible through some kind of Creative Commons license, we don't know if we could also expand their use with artificial intelligence. It's not clear to me. And of course, the sustainability concerns. The sustainability concerns, they may look more related to technology, but this is not only that. I mean, we have also the content upgrade. So, is it possible to develop a more sustainable model in order to cope with these, let's say, negative issues that are around the scholarly knowledge ecosystem? Well, we can do things. I will go to my proposals. First, we have to put more effort in strengthening open access and, of course, adopting less strict licensing models. I mean, open access cannot substitute traditional publication, but it can act as, let's say, a competitive part of this publishing ecosystem and create some kind of paradigm, I mean, introduce paradigms that also a traditional publisher can follow. We should also, based on the first, let's say, proposal, we should also identify the funding initiatives for open access academic books at least. And this will bring a balance to the system. And of course, it has also a great social, let's say, impact in terms of students be able to have access to more content in a free way. Another proposition is to find a way to collaborate across stakeholders, all of them. I mean, libraries, traditional publishers, universities, and now we have the technological means to do that. We can provide single platforms or authoring tools or distribution systems. There are examples in worldwide that we can do that. We can do that in Greece also. And try to focus on efficiency and quality. I mean, it gives us, I mean, the transition, at least for the scholarly knowledge, it gives us the ability to focus on efficiency, meaning quick delivery, easy upgrade, and of course, to efficiency through quality, meaning that the users can, let's say, assess the content themselves. And support, of course, a diverse content distribution model. I mean, one model does not fit for everybody, so we might have models like open access, like pay like subscription, or pay by, let's say, a wider access to a lot of titles, or we should also introduce, let's say, factors for calculating the cost that they are related to the quality, the use, or, I mean, how old is the content, etc. I mean, we can do a lot of things in these directions. And finally, we should also use, try to evaluate and assess all the stages of the creation of ebooks or scholarly knowledge. We have now experience in new advanced models, and of course we can use also information systems and integrate quantitative approach through web analytics, data analytics techniques in order to look into what is the reading experience of users, how much time they use content, if the flow is correct. I mean, we can do a lot of things there. And of course, we can promote reuse licensing. This is important. Okay, I will skip this and I will go to the role of the libraries, because, I mean, we are in the National Library. The role of the library is multifaceted and pivotal in the evolving scholarly communication landscape. First of all, it is important that they should reaffirm their core function and contribution as mediators. I think through this digital world, I mean, the identity of the library is somehow hidden to the users. I mean, users go around, they search in the internet, they click to access an e-book, and they don't realize that this e-book, at least in the environment or in the university, it comes from the library. I mean, we should put there some effort. The second point is that as far as concerns open academic resources, the library should be there as pioneers, and also to try to have this kind of initiatives in the academic environment. And finally, I mean, what the libraries do very well is training, awareness, and user education. I mean, this all new environment needs, library needs to start educating and informing the end users. If users are aware and trained about these change, they will accept the change more easily. That's it. So 70 minutes.
Yeah, you were just on time. Yeah, thank you, Dimitris. The sustainable models, the solutions. You mentioned the role of the libraries and some realistic measures you mentioned. We quickly go on to the list, but last but not least, speaker is Dr. Michalis Gerolimos, who is the head of the Cataloging department here at the National Library of Greece. He has worked as head in various projects, such as the electronic e-reading room, which was mentioned before, the Greek Web Archive, and the support of the public libraries in Greece. So,
thank you.
To go quickly.
Can you hear me?
And your title is the title of the presentation, A National Service for the Print Disabled and the Role of the National Library of Greece.
Okay, thank you very much. If I may make a comment in Greek before I start. Θέλω να ευχαριστήσω θερμά τον Γιώργο τον Γλωσσιώτη που αφιέρωσε αυτή τη σημερινή εκδήλωση στον Φίλιππο Τσιμπόγλου. Πάντα όταν κάνω και μια τέτοια κουβέντα με πιάνει έτσι μια συγκίνηση, συγγνώμη, αλλά είναι πολύ σημαντικό να βλέπεις ανθρώπους εκτός της Εθνικής Βιβλιοθήκης να αναγνωρίζουν τον ρόλο του Φίλιππου του Τσιμπόγλου στην βιβλιοθηκονομική κοινότητα. So, I'm now converting back to English. Stephen made a comment actually about AI when he was making his speech that is both fabulous or it may be scary, something like that. I don't know if you like this presentation. I have the feeling it's okay. You can hear me, right? Okay. So what you see, I don't know if you like this. I like this very much. I didn't do this. I didn't do anything. I just typed the title. I moved into with my presentation, and then when I get back, that was there waiting for me, suggested by AI. And I say, wow, so cool. So it's both fascinating, and it can also be scary if you know how to treat it, or if you don't know how to treat it. Just a small comment. Quickly, the contents of this presentation. I will move ahead with the first ones. It's an introduction of what is a print disabled person. Actually, I will ask you if you know this information, what is the current legal and operational framework. A very brief presentation of the current status, and of course, I will move as to what is the main purpose of this presentation, what was the proposal that we submitted as the National Library of Greece back in 2022. This is the main purpose of this presentation. I was supposed to see my notes. I don't have this opportunity, so I will just try to find it here. Just a question, if you want to, how many people in here know what is a print disabled person? If you would like to raise your hands, please. Okay, so that's quite a lot. That is actually very good. In essence, pre-disabled persons are recognized those who have some form of disability that doesn't allow the use or the proper use of print materials like books. For example, blind people, people with color blindness, they don't have actually movement in their upper hand, so they cannot hold the book. Things that are so easy and so normal for us, they cannot turn the page, or they have some sort of cognitive impairment that prohibits understanding the text the way we do, for example, people with dyslexia. In essence, it means not having the ability to read what others can in a way that others can, and of course, how this affects their lives because affects their civic, their human right of having access to information. This is so important, right? Okay. Moving a little bit ahead, I'm not going to stay with this to save time. This is the legal framework. I think it's well known. It all started with the Marrakesh Treaty. It came to effect with the EU legal framework. It came into the Greek legal framework with the law 2020. We have some exceptional legal advisors that can go through with all this and the legal stuff. I'm not going to go through that. As the National Library, we have obligations based on our own law from 2017. What are the stakeholders? I'm moving now into the operational framework. Of course, are the citizens, because they are the beneficiaries, as it is recognized by law. The creators and the publishers are a very important group of stakeholders, because no matter what we do, we must safeguard their rights, as they are, of course, again, predicted by the law. Libraries and universities with their accessibility units and libraries, for example, with AMELIB, are doing a great job, and they have actually a dual role. The one is they create content and they offer this accessible content, or we should start, I think, talking about accessible publications, which is a more generic term, but also they should, and they do that, they act as intermediates between everyone else and the pre-disabled persons. They assist them, and of course they should, and I think they do that, raise awareness within their public, within local communities. This is also very important. State and its agencies are also maybe the most important key stakeholder. They have the overall authority and the obligation to provide all services and processes for everyone involved, for all beneficiaries, and of course their job is to aid and assist everyone, right? Through this presentation, I will not be mentioning the private efforts, not because I want to discard them or because I think they are not important. On the contrary, but I strongly believe it's the state's business to do this service or any other service and provide that to everyone. And of course, private efforts should complement, should assist those efforts. Now, still on the operational framework, formats and use, this is maybe the formats, maybe is the easiest thing we need to do, and I know AMELIB and other accessibility units are already implementing those. We have the Accessibility Books Consortium. They issued the standards. We've done this as a National Library of Greece back in 2021, and we simply translated everything in Greek. And of course, we have Daisy. And again, sorry, a note. The AI read Daisy, thought it was the flower, and it gave me this icon. And I thought it was so cute, so I left it there. Seriously, I didn't pick that. The AI picked that. Anyway, we have the Daisy Consortium. They have so many tools. I know it's extensively used also by services in Greece. Since I'm debating, of course, that libraries are important stakeholders, we have the IFLA's KPIs. I think that was published in 2012. It's a great way for us to measure our ability, our capability to serve our print-disabled communities. Now, there is a lot of debate about what formats we get in order to create the accessible content, and this is, of course, maybe one of the biggest issues, how to get a form of editable format, just a Word, just a PDF, in order to go from there, and of course, save time and money. It's only normal, of course, it's very significant to have the purpose of this creation, and it's only normal that has been, at this point so far, focused on the educational purposes of blind person people, but I think we all can agree a blind person, when he or she is a student, doesn't stop being a blind person after he graduates, so we should also continue serving more needs like recreational and environmental entertainment. Sorry. What is the current situation? I'm going to go through this very quickly. Like I've said, universities with their accessibility units and AMELIB, the service from the consortium of academic libraries, are leading their way, and they are doing a very good job. We thank them for that. In the next slide, you will see what the efforts of the National Library have been. One thing that is of importance is to determine how many people with print disabilities we do have in this country. If someone has the number, please share it with us. I searched a lot. I didn't find a way. Funny enough, I was searching in the internet and I found a study about Australia where it says 22% of people in Australia are actually print-disabled persons. And of course, to determine and have a way to see all the accessible content in one place, this is the responsibility of the National Library of Greece, as we will see later on. So moving to what the National Library of Greece has done, at least until 2022, where the Philippos Tsiboglou was the Director General. I don't know if you see the green, no, okay. So the first thing we had to do, and we've done that 3 years ago, to determine the format standards. What are the standards, what are the formats that the accessible content, accessible publications should be published in? We've done that. What we haven't done is issue the security standards. And this is not something difficult, because it would be naturally something like an ISO 27001, and it's already there for us to choose. Another thing that we should have done, but I don't think that relies within the scope of the National Library of Greece so much, is to have the standards to define who is and who isn't a print-disabled person. Actually, I think this requires the work of several different ministries, and with the Ministry of Health having the lead. And another thing that we should have done, it's not there, but again, technology can help us do this in a very timely manner, is to publish the union catalog. This is all mentioned in the law that the National Library operates from. And apart from what we had to do, because that was what the law say, we have already made so many efforts, because that was the sense of duty, especially of Philippos Tsiboglou. We started with so many meetings. Myself, I was there in 3 or 4 different meetings within the Ministry of Education. He was in more than 10. This proposal was a product of those meetings. We started at some point in late 22 the ICT service that would consume the information from other Greek agencies, state agencies, as to who is and who isn't a print-disabled person. I don't know how many of you know, his untimely death stopped everything, and no one resumed that, and the team left. We also proposed 2 projects. The one is you are going to see in a very brief and generic way today, and another project that we submitted was how to create and how many books from a physical form in a retrospective way, so it can be an accessible publication as well. Both projects were published or submitted in 2022, and of course, we did submit another one on our own. The first 2 was actually after the discussions with the Ministry of Education. We proposed the third one on our own. It was approved by the European Commission. Should have been run by now. We would have about 3,000 electronic books in a full accessible form, and maybe up to 1,000 audiobooks. All these simply and exclusive for what the law says, beneficiaries, no one else. So let's say someone wants to kickstart this project. Let's say we want to resume it. What we need to do, I've said this, we need to find a way and determine how to retrospectively create those books from a physical form, because I think what with Michalis said, make the presentation about the ebook market, I think it's close to 10% of what is the book trade in country. Please correct me if I'm saying something that is not correct. It's close to 10, maybe 12% of what is available as a book market in general, and I mean printed books. So this is important, but also we need to figure out how to move forward. That means at some point we need to stop creating retrospectively from print books and move forward with having some form of electronic text in order to create, as you can see, in a much lower cost, or to put it in another way, with the same money we can create 3 or 4 books. And our proposal was to do this through the illegal deposit in a very secure and in a way that is very secure, and of course according to the Greek law. Like I've said, a joint ministerial decision is also very important. 3 ministries, I think, should work together in order to have the standards of who is and who isn't a print disabled. Our job as the National Library would be not to verify the print disability of persons, but to say that person is print disabled, okay, this is verified by the Greek agency that has the authority, and then we authenticate that user. That's only normal, right? Okay, thank you for agreeing with me. That's very important. And of course, we must do 2 things, like I've said, issue the security standards, publish the union catalog. In my opinion, we should run the national service if that comes into existence, and we could also prepare these books as an in accessible format, simply because the National Library has all the books. There is in law 1 parameter that say that you need to legally own the copy, so we do have, or we should have, all the copies out there. Δεν έχω λίγο νερό. Το έχω αφήσει εκεί, συγγνώμη. So let's say this happens and we start this new project and we say, okay, let's go and see what this service is. I think we should set some goals and some strategic planning involved. The first one would be to have an... Ευχαριστώ πάρα πολύ. Συγγνώμη. To have a one-stop shop that all involved parties would have to access only that. All the beneficiaries, the publishers, the content creators should have one-stop shop. That's it, nothing else. We should create this not as a single integrated system, but as a system that will interconnect with others already in existence. We are not planning to get everything from others and run it ourselves. There are so many services running, and we should just find a way to connect that and provide access seamlessly. One of the most important aspects would be to find a way to verify and authenticate the pre-disabled person with 1 click, and then from that create the registry of print-disabled persons. And that would be, of course, a national service. It would not be a service for this system, but it would be a national service for everyone to use. Technology allows us to do so many things today, and of course we can find a way to connect existing repositories in a way that we will get a final and end result. We would know how many accessible books are out there. And of course, since I'm talking about the service that will be distributed throughout other services, having inclusive processes should also be a goal, but I'm going to stress this, this service would be only for those who have the access to get there, only for the beneficiaries. I've said we need to find a way to retrospectively create the content, but also I think we should gradually adapt its operation to serve as a just-in-case and a just-in-time service. Just-in-case means we would have some form of e-text to be created, and it would be there forever. And then just in time means when a beneficiary asks for the book, then we will create it and give it to him in a timely manner, right? Πώς πάω? Τελειώνω? Okay. Άλλες 4. Okay. I'm going to go through this very quickly. I'm going now into the national service. It would have 3 pillars. We've seen that already. The first pillar is the beneficiaries. They are determined by the law. The second would be the infrastructure and the applications through proper processes and, of course, application of standards and what the provisions of the law are. And, of course, the third pillar would be to have the publications in order to offer them. Moving quickly to the next one. This shouldn't happen. Okay, this is... Let's see quickly the underlying technologies. It is our belief, this is what we proposed, it would start with illegal deposit. This is an easy way to secure the illegal deposit that was deposited in the National Library. That would be there, not for the taking, but we can create something from that. The second, it would be to have the authentication service, like I've said before, that would authenticate and coming the information beforehand would verify who is and who isn't a print-disabled person. The registry is very important. This is one of the things that we need to do as a country, regardless of this service or no. It would have the request application. People would say, well, I am a beneficiary, and I want to have this book delivered to me per law. The repository applications is another technology, of course. Like I've said, it can come in various ways, and the way that it will be connected through the ones that are already in existence and the ones that will be created for this purpose. Of course, it would be a GRM service. I think, Michalis, it should not be something outdated. We can agree upon how to serve this and how to use what technology is acceptable by all parties involved. So this is one of the things that when you come after some time and others have experienced everything, it's easy to see, well, this worked, this didn't work, so let's pick the ones that already worked. And of course, the tip of the iceberg should be the catalog, the union catalog. This is where the beneficiaries should have the only experience, and he or she should not care about what happens below. And of course, all these technologies should somehow interconnect. Technology allows to do this easily. We need to decide on the implementation plan and the organizational stuff. I'm going to go through this quickly because this is actually what we've seen already in a different way, but this is what I would like to be something that we remember from this presentation. The goal here is not just to create one service that will overtake all the other services, the exact opposite. The goal here is to create an ecosystem centered around this service that will have mostly administrative functions that would bring everything together and save us so much time. But on the other hand, every involved party, every interested party, like the National Library, the AMELIB with academic libraries, like the universities, can connect. And as you can see, we have had many circles to signify other agencies, other organizations can connect into what should be considered as an ecosystem of providing accessible publications to the beneficiaries. Now, what if, instead of... Προχωράω, okay. Σου πω να βύχεις. Λοιπόν, okay, so we could, instead of paying all that money for the academic textbooks, we could invest like a 5 or 10% of that for 2 or 3 years to create the service and create most of the publications in print format into accessible content. And trust me, that would benefit everyone involved, not just the print-disabled persons. If we had the mentality, I think it was Sharon that says it's so hard to change the perceptions. This is the most important thing. How are we going to perception that every new published book could be offered in a secure way as an editable format? How are we going to change the mentality of investing in the process and not in the print document itself? And of course, the most important mentality, and I think there are so many people that are working towards that end, to have an understanding that when we create a book, that book should be considered as a book that would be created as an accessible book in the future. I would like to make some acknowledgements. Apostolis Dimitropoulos, Philippos Tsiboglou, and Georgios Glossiotis, they've done so many meetings, seriously, within the Ministry of Education. They should be acknowledged. And personally, I would like, yes, you, don't try to hide. Dina Kakali has helped me so many times for the last 4 or 5 years. Every time I ask something, she was there giving me all the information. I'm not going to introduce Dina because she's in the panel later on. Now, finishing this, please, we need to keep always in mind there are so many ways to communicate things. There are so many types of communication. In written word, we are accustomed in having what is, for example, symbols that signify the common language, right? What is common for us. But it can also be Braille, or it can also be the oldie but still goodie Morse code, or it can be a binary. Regardless of the means of communication, the same can always remain the same. In this instance, it says, thank you for your attention.
Thank you also. I would like to thank all the speakers, the 5 speakers. All the presentations were very important from the different perspective on AI and e-books and libraries.